We are live.
Good afternoon, everyone. My name is Leonard Austin. I am the Vice Chair of the Commission and Chair of the Legal Committee, and I call the Legal Committee meeting to order. In just one, we have present all members of the Commission. Commissioner Carney, who is remote in Syracuse in a public area.
All members of the committee.
All members of the committee.
Right.
That's it, Commissioner. Thank you. And our chair, Frederick Davey, is present as an ex officio member, as is our executive director, Sanford Berland, and our general counsel, Keith St. John. We have an agenda that is a little ambitious for the time that we have, and I'd like to thank everybody for being here, being prepared, and being ready to go forward. The first item on our agenda is the Commissioner Code of Conduct. I would call on our General Counsel, Keith St. John, to give us a rundown of the differences between what's been prepared for us than we have with respect to the Code of Conduct that is being recommended now and that which existed with JCO.
Sure. Good afternoon, Commissioners. You will hopefully recognize the substance of the proposed Code of Conduct. It is from this draft, essentially, that I sort of offered my remarks at a prior workshop that we went through with respect to the committee day, in fact, when we tried to sort of highlight what staff recommendations might be for agenda items for the various committees. Here before us is the basis for that presentation. I'm going to roughly describe the proposal with some contrast with respect to the former, your predecessor agency's Code of Conduct, that is for the former Joint Commission on Public Ethics. Suffice to say, the proposal that's in front of you is in large measure modeled after that prior Code of Conduct for the predecessor agency. What you have in front of you started with what JCOPE used to govern its procedures for both meetings and Code of Ethics internally, and so that will form our jumping off point. With respect to certain provisions in what's before you now, the proposed Code of Conduct, as I say, having been modeled after the JCOPE Code of Conduct, they're similar in virtually all respects except for the following. There's an additional paragraph that was added to the bottom of the first page of the proposed code. That paragraph beginning with "No member shall, without prior authorization by the Commission, engage in ex parte communication between them and the selection member or the representative who nominated them to the Commission with respect to any matter that is or may come before the Commission, nor with respect to any other matter unless the fact of such communication is promptly disclosed to the Commission in writing." That is a new provision, as well as the following paragraph: no member shall engage in ex parte communication with any person who has any interest, direct or indirect, in the operations of the Commission. Those two paragraphs were not in the Code of Conduct for JCOPE. Staff is recommending that those two provisions be included in the new Code of Conduct for your consideration and that of the full Commission. Commissioner Ayers has raised some questions about some of the language, and I'm prepared to address those and perhaps offer some greater particularity so that there's a more easier way to understand the terminology that's being used. Quite often, we tend to default on terms of art that we are most familiar with, forgetting that those terms of art are indeed terms of art and express or in some way are euphemisms for something else. So let's get to what the something else is so that we're all on the same page. With respect to the term selection member, Commissioner Ayers is correct in remarking that that phrase really comes from the statute. And I think quite often we endeavor to mirror regulatory language or prescriptive language or even proscriptive language as it is set forth in the statute. But the Commissioner, I agree, makes a good point. So I might replace the phrase selection member with either state officer, and I'm going to tell you why I don't really want to recommend that, but that's an option, state officer or public official. The reason why I would not recommend replacing selection member with state officer is because state officer is in and of itself a term of art that is defined in the public officers law. So rather than rather than replace one euphemism for another, perhaps the easiest way of expressing what we mean by the selection member is simply replacing that phrase with public official. In every case, we're talking about the individual who can only be a public official. That is either the governor, one of the 4 legislative leaders, the attorney general, or the controller. Those are all state officers by virtue of the public officers law definition and their elective office. So public official would accurately and most broadly capture the population of selection members
That works for me.
that are the subject of this paragraph. And again, selection member, for those, just so that there's no misunderstanding, by selection member, we're talking about the individual who nominated any given member of the commission to the commission.
Yeah, and on reflection, maybe we want to go with appointed, because they are the appointing authorities. Although we do have the IRC system, the appointment still reverts to those public officials. Although it comes to the same thing. They were
Yeah,
not
appointing authority
nominated, selected.
is another euphemism now,
No, I
unfortunately.
think what,
Because it was a
correct me if
selection.
I'm wrong, Sam, but I think what you're saying is the public official who appointed them to the
Yeah,
commission.
yeah. Who appoint, because it's a selection process
This is really-
and a
this is more than a
nomination
nomination,
process.
They actually appoint,
Yeah.
they actually have appointing authority.
Well, but
Yeah.
that's included in the rest of the sentence,
Yep.
following selection member or the representative who nominated them to the
I
commission.
think he's saying replace nominated with appointed.
With
because
appointed.
they actually-
With-
Oh,
this-
oh,
We
oh.
should probably do that.
I
Because
see.
now that we're taking selection member out, which referred to that process, let's make it appointed.
I mean, the statute says to be nominated by the selection members, and I'm
Yeah,
just looking for the word appointment in the statute, and I don't know that it's,
In effect, the appointment comes as a result of
The appro-
being nominated and approved by the IRC.
quite right, and I'm not sure that the
then don't they-
nominating member is the one who appoints. I think that, in the statute, that seems to describe the collaborative process, or the two-party process.
Commissioner James?
I thought that after it was approved, those individuals made announcements that they had appointed each of us to the
That
to
could
the
be
commission.
Yep.
Okay, I have a substantive question when we get to it on this paragraph. I don't mean to belittle what you.
No, I have I'm fine with appointing or nominating. I think it's sufficiently clear who we're talking about.
I'm just wondering whether or their representative should be after the phrase who nominated them to the commission with respect to nominating to the commission should be after or their representative.
well, that does avoid
Because the
an
representative didn't
unintended
nominate.
ambiguity there, yeah.
That would be bad. I mean, I still have questions about what
Who
the
the
representative is.
Yes,
so we could-
and I'll get to that, right.
But I
That's
agree
when I
with
flip
Len.
the page.
Yeah, yeah.
Commissioner Cardozo?
Was there a substantive event that caused you to suggest this additional paragraph that we're talking about? that we should?
I don't
be
know
aware
that any single event, but rather suggestions that have been made
of? Just-
in
just-
the early months of, the existence of this new commission. Certainly, it is a suggestion that was made at the public hearing late last month with respect to communications between commissioners and their appointing authorities. The good government groups have weighed in on that and have a particular opinion on whether those sorts of communications are appropriate or how they might be circumscribed.
And then if I could just pursue this, is the reference to without prior authorization by the commission, do we need to spell out that authorization process more? In other words, should there be a vote? Are we asking for trouble if we add it in following a vote?
I don't think you need, I frankly don't think you need that phrase at all. I mean, why should,
Well, that was my,
we shouldn't be doing it, period.
I don't think you need the phrase by vote because any authorization of the commission requires a vote.
okay. But then I was going to ask Glenn's question is there a situation where a commissioner might say, the governor just called me and wants to ask me about X, Y, and Z. I'm sure it's okay with everybody, right? Is that something that we would say yes to? And Fred and I just thought of an example that we
All right.
faced.
Let me go a little bit out of my order, but address that very question. Commissioner Ayers has again wondered out loud whether you needed prior authorization by the commission, and then at the end of that same sentence, if not paragraph, prompt disclosure to the commission. Those two extremes don't seem to work together, one might argue. I think they do for this reason, because there are a variety of instances which may give rise to a communication between a commissioner and their appointing authority. Either a communication that's initiated by a commissioner or a communication that's initiated by the appointing authority. If the communication is initiated by the appointing authority, well, then you can't get prior authorization to engage in that communication by the commission in the first place. So that's when, if the public official has communicated with you on their own initiative, this code would have you then immediately, or as soon thereafter as is practicable, let the commissioners know that appointing authority chatted with me the other day about such and such. You ought to know that. Versus a communication that's initiated by the commissioner, him or herself or themselves. Once a commissioner knows that they have an interest in speaking to an appointing authority, that's when, if the communication is done at the initiative of the commissioner ought to get prior approval from the commission.
Commissioner James?
So, actually, I think Commissioner Whitney,
Yeah.
I'm sorry, I didn't see your hand.
her hand will be focused on.
Thanks. So as it relates to this paragraph, I am a little puzzled by what, with respect to other matters, mean exactly. And it seems to me that if we have stated explicitly that you should not speak to them with respect to any matter that is before the commission or may come before, that should be sufficient. But when we go further and we say any other matter, unless those facts are communicated to the commission, I think we are doing what we set out to say. Like, it would be unwise or unjust to prescribe them by statute and be inflexible, and the penal sanction which would limit public service. I think that's where we're heading, because this seems overly broad. You can't talk to the person, you can't talk to their representative, that's what I'm getting here, and we are setting ourselves up to fail. You raised the example about the professors. Most of us, except for 2 commissioners, are attorneys. You're constantly talking to individuals, and it really puts a burden on you. You're at an event, you're talking to someone, you can't discuss it. This is overly broad and really set us up, in my opinion, for failure, and what we said here, that it's really inflexible and should not be put in by statute. So I don't think that language is necessary there. And then for the second paragraph that you put in, well, we can stop there, but I wanted some more clarity and explanation as well.
There is a little bit of background. There was discussion in the prior commission. JACO, part of it prompted by concern over disclosures of confidential information. And there was something of a history of a controversy over that, stemming from a vote that had been taken in executive session in the prior commission, and whether there had been a leak, and there had been an investigation by the Inspector General as required by the statute. And there had been consideration of a number of mechanisms, many of which were implemented for preventing recurrences of that kind of thing, which was of great concern to a number of people. There had been a proposal to have no communications between commissioners and appointing authorities or interested persons at all. And I think the upshot of that was that probably too restrictive, that there ought to be instances in which commissioners could properly speak with those in various agencies of the government, offices of statewide elected officials, and so on. And that instead there should be reasonable mechanisms to ensure that there was transparency, at least, if certain communications were taking place. And one proposed balance that was attempted to be struck was one where the commission as a whole would have to authorize a communication with an appointing authority if it involved a matter that was before the commission. And the commission as a whole would decide whether it was appropriate for that conversation to take place. And with respect to anything else, if it didn't involve a matter before the agency, at least there would be transparency, because there would be a report as soon as practicable that so-and-so had a conversation, and this is, it didn't involve anything before the agency. Whether it would get into the substance or not, the proposal didn't attempt to address. And that's why it was there. So it was intended not to be too restrictive, but at the same time to assure the public and the other commissioners that there were no, not just untoward, but no conversations taking place that might raise concerns or questions.
As is here, it seems, it appears to me to still be very restrictive when we have any other matter. You are almost saying, you can't go somewhere, speak to someone without disclosing it. You can't, you're really cutting off that communication. There are people that are in organization, you speak at a reception, you're having a general conversation, and you need to disclose that. I think that infringes of, we give up some privacy when we're a public official, absolutely, but we shouldn't have to give up every single privacy, and this goes a little further.
Would it resolve the issue if we said any other commission-related matter?
I mean, absolutely, but I think we said that already by saying that is before or may come before, so that's redundant in that respect.
I know Seymour's been waiting. I'd like to get in the queue as well.
Yeah, I think we really do, we need to distinguish between matters which are before the commission and every other matter. And I agree that if there's going to be any communication between a member of the commission and the person who appointed him or their representative, that either needs to be approved by the commission in advance, or it should be barred entirely. But with respect to the second category, I agree with Commissioner Whittingham, I think it goes too far. It's too restrictive. I don't personally have a relationship with the person who appointed me, but I believe there are people on the commission who do have relationships with individuals who appointed them, and to prescribe them. And the way it's written, it is ambiguous because it says you have to speak before and then you have to report it afterwards. So I don't know that we necessarily, there really should be no situation where you have to commission's authority to speak to the person about something that's not before, or that's not before the commission, or may not come before the commission. And so I think you could, I guess if you wanted to have that requirement that you speak to that you advise the commission afterwards, I think you ought to have two separate sentences rather than that nor there. I think it might clarify it a little bit. Because nor could apply to the first section of that sentence. If you had a separate sentence, then you'd be saying that there's one rule for matters before the commission, and then there's another rule for matters that are not before the commission. Did I make that clear?
I don't think that's what nor means, but perhaps we can,
I do
Just-
think Seymour has a good point. If
I think-
you're talking to a representative of the person who appointed you on something totally unrelated to the commission, we're saying, oh, by the way, Mr. Commission, I'd like to talk about a baseball game with counsel to the governor. We have to do that. We have to do that under this, right?
As it's written today.
Yeah, I mean, and it could be in the nature of, by the way, I was approached by so-and-so, I ran into such and such a person, and we had a discussion, it had nothing to do with any matter before the commission. But, lest there be any concerns. I mean,
that's-
would be the scope of it.
I mean, what if I'm at the Nassau Bar Association and a member of the assembly is there, and I say, the commission recommended this bill. What's going on with it? Do I have to report that?
well, it's not a matter that would ever come before us in terms of legislative action.
So that would be something that I would not have to,
But under
As
the
it is
current
written.
drafting
the
of
way
the
it's
proposal,
drafted,
yes.
yes.
Yeah, you
And
come
it-
to us afterwards and say, I had this conversation with such and such.
Do we want to?
And again, I'm, I've got no skin in the game here. What I think the staff is definitely trying to do is, as well, attend to any actual conflict, but also provide sort of boundaries so that you don't even get to the appearance of a conflict.
Well, appearance
Try
of
to-
impropriety is just as
Yeah,
important as the
yeah.
action.
And because one can be having a very honest and legitimate conversation with their appointing authority, because you share the same daycare for your children. To the bystander, it may look different. And so so the bystanders, and I remember sort of trying to repeat this when I gave that committee day presentation, it's not so much what you think as you're sitting or standing in your own shoes, it's what someone else in others, what the person in their own shoes might think of our behavior on the commission. That's the person you want to worry about and think about with respect to how might the innocent bystander view my very innocent conversation with my appointing authority. The innocent bystander may be naturally suspicious of that otherwise very legitimate conversation. So to address and mitigate that understandable suspicion, one might want to go so far as to make as remote as possible the possibility of these side conversations.
Commissioner Ayers.
Go ahead.
Yeah, and I know others are waiting too. I just wanted to say, I think, a couple things. One, before we get to the wordsmithing, I think we should settle on what we actually want to restrict and prohibit. And as I said before, in the email, I have a question about who counts as representative. I think this problem is a little bit more acute for me than for some others because there's 1,700 people who work for my appointing authority, some of whom I have to supervise or work with. And if you include interns who are paid staff, which seems to me sort of silly, but I'm not sure how to draw the line.
Sorry to interrupt. My quick response is no staff, no interns. The representative that's contemplated in both statute and in these rules is the person for whom written authorization has already been provided that my general counsel will perform in my stead. For example, the attorney general is going to direct someone to act in her stead, speaking on the behalf of the office or attending a meeting. It's not just any and everyone in the OAG is a representative of the OAG. It's only one person who the AG designates.
Well, I'm not sure. Every brief we signed was in the AG's name.
Well, if I may, do you mean something like with the hearsay rule, someone who has speaking authority?
I don't know that I'm going anywhere near that. I'm just suggesting
I
that
thought that was an easy one.
One's representative is only going to be an agent for your appointing authority if that agency has been clearly expressed.
Well, let me just say quickly before we move on. Two things. One is I know that Mr. St. John had an order of things, and I want to make sure that we don't derail you in case you actually want to get to things. I do think we should do the substance before the wordsmithing. The other thing I just wanted to say was I think my instincts are a bit different from my colleagues, although I certainly respect the point. And to me, part of the point of this is not just I think the appearance of impropriety is really important, but the other thing is what's going to happen when something goes wrong, right? When there's an allegation that information has been leaked, as there was with our predecessor commission, how are we as a body prepared to reassure the public either that nothing improper has been done, or that we're able to effectively take steps to make sure that nothing improper was done? And so I'm personally very open to the idea of documenting, and even if it means documenting as a general matter that I interact with interns, I'm okay with that. I can't share the names of the interns because I think FERPA says I'm not allowed to do that. But in other words, I'm open to fairly fulsome disclosure to the commission because, again, I think, if one of us is meeting weekly with the official who appointed us, then that's something that's going to become very, very relevant when there are public questions about the flow of information between the commission. So I just wanted to say that. The final thing I wanted to say, I promise, is that I also think, to me, there's actually three categories of information. So there's matters before us or that might come before us, but that to me seems to refer to something like investigations, specific cases. Then there's also general information about the commission, which is not, so irrelevant stuff, baseball games, I'm open to disclosing that we've been chatting with folks. I don't see a problem with that myself. But I also think there's an intermediate category of information that's not a matter before us, but conversations like this one, where we may be in public, but so it may not matter. But there's quite a lot of things we do that are not, in my mind, so there's a third category that's not currently addressed in the context. And I think it'd be useful to clarify people's positions on all this.
So perhaps that section needs to be broken out in terms of communications and appearance of impropriety, perhaps, and two separate writings in terms of that. Commissioner Whittingham.
Yeah, I go back to the point to say I understand the appearance, but I believe, as we say in the preamble, it would be unwise and unjust. Further, we can provide for regular and systematic contact with the representative. And that can take care of a weekly meeting, staying at the daycare, because that's regular and systematic. And that can be provided for within the regulation and be very specific. But I really think we should not set ourselves up for failure by putting in rules and codes of conduct that we can accidentally, right, violate. I will go to 10 bar association events, and I will speak to somebody here, and then I have to say, oh, I gotta tell you, I may have just ran into you, and then I have to do that. And I personally is someone that goes to a number of them, and I'm not gonna vote to set myself up for failure.
I don't think there's anything wrong speaking to the person that appointed you about matters that aren't before us or don't come or are going to come before us if it's just casual conversation. And I don't feel any obligation to disclose that. If I see the person that appointed me, which I don't that often, or nominated me, and I said, you know, how's your day? How you doing? You know, Yankees game. I just don't see that there's an appearance of impropriety, that if somebody saw me speaking to that individual, and I don't think it's even the spirit of any of the rules that it's even comes close to a violation. And I think this provision should end with commissioner, period, and the language beginning with nor thereafter should be eliminated.
I agree with that.
Wait, I'm sorry, you said end with commissioner?
Yeah, I think he
Commissioner.
meant, he meant
Before the
commission.
commission.
I think it means the second commission? You mean the second word commission?
In the third line.
Yeah.
Just before nor.
Before the word nor.
Got it, okay. No, that's the third word,
Oh,
commission.
okay.
Right, that's where he meant.
The third one.
The third one.
The clause from nor
So
to
that
the
it,
end
so
would come out.
so that it would read, no member shall, without prior authorization of the commission, engage in ex parte communication between them and the public official who nominated them to the commission or their representative with respect to any matter that is or may come before the commission, period.
I would go along with that.
Is everybody agreeable to that?
Yeah.
It's not my
And the
view.
balance of the sentence then would be removed.
The only thing I would say is their representatives should follow, just a little technical syntax.
No, I moved it to.
I would say
after
it
the
should-
com-
Yeah, it should follow after the elected public official or their representative, that's all, but that's just a.
Well, we have who
Okay,
nominated them.
It may suggest that
Got
the
it.
representative
Got it. I got
nominated.
it. Okay. All right.
Okay. Is there any other, on the first paragraph, are there any other comments or thoughts?
Well,
One
yes,
other
it's
thought.
part A.
Oh,
No,
sorry.
please go ahead. please.
I agree with what we just said. The only thing I am thinking is how do we know, or may come before, may reasonably come before? We might want to put that word there because it seems a little broad. I'm not quite sure how we would determine it. But if you have some sort of indication, but I think may reasonably come before is what, because I'm not sure if it's left that broad, if we really know what it is. I agree, if you have some indication, this might be coming before the commission, not at all. But I could foresee that you don't know, right? So that's just my query about that.
This may actually be responsive to that so my thought was I wonder about changing it from any matter that is or may come before the commission to any commission-related matter. And the reason is, like, I don't think we should be talking about commission personnel issues with our appointing authorities either, even though that's not a matter. And I also don't think we should be giving them ethics advice, right? Like, even though that's not a matter that comes before the commission. So I think if we change that, would that address your?
It may. The only question I have, which it sometimes is a little confusing, because we're now public, we're having a public discussion, right? Anything that is stated publicly can, we're not, I don't want to, and I'm not doing it, but anything that is stated publicly, how do we claw that back? to put it in the, it's.
I don't think we should, I mean, well, I think I have a different view from the groups. My group is, my view is, why would you need to be
No.
talking about that? Like, I don't think you should talk about anything public with your appointing authority.
I am not saying that I want us to be doing that
Yeah.
conversation, but I can, if someone said, oh, I saw this matter and there's a general conversation, if we can speak to another public person about it, why can't we speak to, again, not trying to have an in-depth conversation about this, but if the information is public, because we're live streaming it, how do we make that private again?
It's not private, it's just not, that's like a judge can talk about an interesting case that's in front of them with students, but I really would stay away from it when you're talking to the lawyer in the case. It just seems like good practice to me.
Or the press.
Or the press, right? I wouldn't, I mean, it may be public, but I still think there's certain people who you just want to avoid. Because it's not, because you're not, the concern isn't the sharing of information, right? I mean, that's a concern, but the concern is the appearance of influence.
All right, so the suggestion is that we change with respect to any matter that is or may come before the commission to any commission-related matter.
That was the suggestion.
That was the suggestion.
In what tense is the word matter in that context? Is it present or future? And I don't know that it's future.
Well,
If it-
I think that's part of the.
Was I,
No, no,
Yeah,
you
you
understand
were
me?
clear,
Yeah, I
because
see.
it says that may come before, and to Commissioner Whittingham's point, to some degree, you're gonna have to have a crystal ball unless you're thinking about what reasonably might come before the commission. I mean, because I mean, to a point, you could inadvertently slip into something, right? I mean, something could be as far away as Niagara Falls from where we are at the moment, in terms of what it's going to mean for this commission at the time you're talking about it. And then a week later, it blows up and you realize, wow, this is going to be something we have to consider. It didn't even seem like a remote possibility a week ago.
I mean-
Reasonable foresee, I think it's what we're, except for the chair and Commissioner Edwards, we're all attorneys. I think we understand what reasonable foreseeing mean, like foreseeable. We use it all the time in the courts. So, we can't see, we don't have the crystal ball, but that is, a term of art, but we see it every day in the papers. I think by now, most of us may have an idea what that means, so we could include it.
Certainly at regular meetings, we know what we cover and what we don't cover and where things go and whatever. Commissioner Carney.
Yeah, maybe something to the effect about that the member has knowledge that may come before the commission, knowledge or reasonable belief may come before the commission.
This was mine.
And I get-
So the suggestion with regard,
I get what the intent is, that my point initially with the nominating individual, the person that nominated me or anybody, I get that, I wouldn't have a conversation about any of the business, to be frank with you. But, I don't want to be prohibited from speaking about things just in general, just pleasantries. But, I am a little concerned that something that may come before us, for you to the other commissioners' points. So I guess if I had knowledge it was going to come before us, I shouldn't speak about it. Or I have a reasonable belief that it might come before us, that would be prohibited.
I just want to say, and this will be the last thing I say because I know I'm not speaking for the majority of the group, but to me, the example that the chair just gave is exactly why I'd rather be prohibitive. If you've been talking to somebody about a matter, and very reasonably, you had no idea that it might come before the commission, and then a week later it does, we're in a bad position, publicly. Yeah, and not because of any culpability. It's not because anybody did anything wrong. But I think that's a situation we should assiduously try to avoid finding ourselves in, which is why I would be in favor of a broader prohibition that says, you know what, you members of the public, you don't have to worry. There's no chance that we were just speaking to somebody a week ago. And then if that matter found its way in front of us, and we know that because we're being very careful.
Because we're not speaking to them at all?
Or we're not speaking to them about public ethics.
About
I don't know how to
citizens,
frame the requirement,
right.
but we're not speaking, I don't even want to talk about my plain language suggestions. As much as I love them and as irrelevant as they are to any possible fact pattern.
Can it be, let me ask, can
Yeah.
it, because we had it in there, we've taken it out, can something like that at least be partly cured or mitigated by disclosure after the fact? If
Sure,
it's
just
subsequent-
recusal.
Yeah.
So
That's
maybe
what it is.
we want
Yeah.
to put some of that language back in as a corrective?
Yeah.
Sure. And again, I know I'm not speaking for the groups. I just wanted to share my position. That's all. I'm happy with whatever you all.
Putting that language back in, I'm still opposed to it.
Yeah,
I'm still
let's
opposed to it.
assume
If we're
that-
putting back this,
Well, I don't mean necessarily verbatim,
whole-
but at least the concept of, if you later discover that the conversation you had is about something that you didn't
Okay.
realize, but now it turns out it's a
that's different. That's what I said. we
So it's a
should-
corrective or a curative or a mitigating
Commissioner Carney?
mechanism.
Yeah, that's all my point was exactly what the executive director stated. In other words, there might be another obligation. In other words, if innocently something was brought up generally about a particular matter, not specifically, you didn't think anything of it, you know, how about that situation or some political situation? And then at a later time, you discover that it is a matter that we are investigating, then you've got an obligation to recuse on it. And so that would be a,
Yeah.
you know, a belt and suspender, you know, point. But
Yeah.
if you don't
Specifically
know
related to that.
particular matter that may come before us and it's innocent, how can you be bound by a rule that you don't even know that it's going to come before us? Find out.
What kind of disclosure
Well,
and
recuse.
recusal language would, yeah?
You know.
What kind of disclosure and recusal language would work then?
Now, in that instance, I believe where it is, we find out later on that it is related to something that is coming before the commission, then absolutely, we should disclose that at that time, and possibly not just disclose, but recuse
But how do
ourselves.
we- yeah,
If
sure,
you look
but how
at
do we
page,
capture it?
well, if you look at page 3 of tab H for tomorrow's meeting, situations where recusal may be required, the second bullet is a member should recuse themselves from any official matter if they had any involvement in that matter prior to the commencement of their commission service. But we may want to expand that to any matter in which they became aware prior to the matter being in the commission. I'm not the wordsmith.
Yeah.
Part of the
But-
challenge here is though, it's not just becoming aware of the matter, it's having had a discussion of the matter with the persons appointing public official or that public official's representative. And I guess the question is, how do we capture that?
I think we added to the same paragraph there. We don't have to put it way down here, so it's very specific to that language. And we put a sentence there that specified what we just stated, that if, there is, the matter later comes before the commission, that we would disclose it and recuse oneself.
I agree.
And we have that sentence right there.
So,
Keith, you got it?
I hope so.
You might want to temper that a little bit and maybe recuse if recusal is required in accordance with the standards articulated below. Because I think it would depend upon the nature of the conversation.
We can do it that way, but the more restrictive way is a refusal so that there's no question The appearance of impropriety is what we're saying. We want to restrict. I think the recusal is a harsh measure, but in that instance, I believe it's appropriate.
Yeah, for whatever it's worth, obviously I agree with that because I'm from the other direction in general, but I think, the concern here, as I think the chair was saying, is partly, we're supposed to be independent of our appointing authorities, and so we want to make clear people understand that we're not being influenced in our votes and decisions by them, and so anytime you've already had a conversation with your appointing authority about a matter, there's a risk that your view of it is going to be shaped, even if they just go like, oh, I heard about that, but it's no big deal. And that's a very innocuous comment. But if you care a lot about your appointing authority, that could still affect your view of the case. And I think, it's not impropriety. There's nothing about improper, there's nothing improper about that interaction. But there is a danger that we'll be influenced, that we won't be independent in the anticipated way. And so I'm more comfortable with Commissioner Whittingham's version personally, again, for whatever that's
So
worth.
what's the language, though? Do we have it?
We'll get a sentence and we'll revise it. I think that we may have to have some revisions and then review and vote on it, so we can do that.
Yeah, I think the idea is if there's been any communication about a matter.
That later comes before the commission, such commissioner should recuse
Yeah.
his or
First
herself.
disclose and recuse.
Disclose and
Disclose
recuse.
and
His or
Yeah,
herself.
yeah.
Yeah. I
Got that one, Keith? All right. So we made it through the first paragraph.
Oh, no.
I'm afraid we haven't.
Okay.
Commissioner Ayers also sort of out loud pondered about the Latin phrase ex parte. I might replace the phrase ex parte, which to the average, to your point, to the average reader and audience member could be Greek instead of Latin. It's still
Foreign.
incomprehensible. So I might replace ex parte with, my sense of what ex parte means, any communication made outside the presence of the commission.
Oh, sure.
Perfect.
So if I had dinner with someone, as I did last
And I'm sorry, because to Commissioner Ayers' point, and to the public that's listening, ex parte may suggest an adversarial relationship between folks that really isn't
Right.
at issue here.
So
or
I had dinner,
existence.
but I had dinner last night with a friend of mine. He said, "What are you doing tomorrow?" I said, "I'm going to Albany." "What are you going to Albany for?" "I have a commission meeting." "Oh, that commission meeting, yeah. Is it keeping you busy?" Now, if I start talking, in fact, I have a committee meeting before the commission meeting. Haven't I engaged then in a communication with a person who has knowledge and who is an interest in the operations of the commission?
Okay, I think not, well,
That's
of course,
paragraph two.
it begs the question, what do you mean by interest? Okay, so there are examples that follow
Oh, yeah, that's a different.
under the recusal section, which illustrate what we mean by
You don't mean
interest.
that.
I don't mean, oh, you've got a general polite,
Right.
curiosity about how your friend is, what your friend is doing tomorrow. I mean an interest, i.e. financial.
Right, okay, so I think, but you see my point.
That's
Yeah,
paragraph
and
two.
that's why I'm suggesting that
Because I
recusal
had a
should be in
question.
accordance with the standards and not a blanket just because
Right.
there's a communication.
But that was, I think his question was paragraph 2. We were still on paragraph
Oh.
1, because paragraph 1 doesn't have that language. I had questions about paragraph 2 as to the whole explanation as well, and the interest and operations. So they're two separate things, and we're going to be specific in paragraph 1 as to that recusal.
To the appointing authorities,
Yes.
okay.
I liked Mr. St. John's suggestion on replacing ex parte with outside the presence of the commission. But just to be clear, does that mean outside, is the commission there refer to these, like a quorum of the commit? The presence of the commission only happens when there's a quorum of us, right?
Yeah. So can there be more, one or more commissioners?
I'm just not sure how to know when I'm in the
Yeah.
presence of the
Yeah,
commission.
I kind of thought,
Yeah.
again, great question.
yeah.
My thinking was outside of a meeting of the commissioners.
I wonder about
personal communication.
personal communication? I mean, yeah, I wonder.
About any matters may come before. the commission.
Does personal mean like non-public?
Why not just communication?
Yeah, because if we're going to be on the same TV show, we can disclose that in advance and satisfy the policy, I think, right?
I would think so.
Because it says without prior author. So if we get prior authorization, we can be on a panel with our appointing authority. We can have dinner with them and do anything we want because we've got prior authorization. So maybe just any communication because prior authorization is there.
And I think we're definitely gonna have to be specific. I know you were trying to explain it, what representative is, but I think I need to know
Oh, well,
that
that's my,
explicitly,
yeah, that's
what
the other
that
thing.
means.
But let's, did we solve ex parte? If we just say any communication, does that lose anything that has value? It works for me. They're not gonna come to our
I think
meetings.
ex parte is superfluous, really.
But interest
Yeah.
has to be
It
defined in
confuses
some way.
Well, in the next paragraph, we'll
Yeah.
get, no, absolutely agree, yeah, when we get there.
I prevent outside the view or non-public, private communication.
I mean, again, I think it's meant to reflect any communication that the commission doesn't already know about or doesn't know about.
Private communication.
I think as hard as it is, Commissioner Carney, I think that disclosure and recusal is about the only way to make this work on anything when it comes to the person who appointed us or their representative. Now, I realize we're gonna have to define what representative means, but I just think I don't know how we get around it. And it keeps us all out of hot water. Quick email to Keith.
In other words, don't omit the.
I'm sorry, Ed, could you speak a little louder, please?
I said, in other words, Chair, are you suggesting don't omit the language nor thereafter? Or,
We can leave the language as it is, but I think that should we find ourselves, and I don't know how we address this, in a position where we have engaged our appointing public official without prior authorization, then the best way to deal with that is simply disclose it, no matter if you talked about the Yankees game.
Then you take out the nor
Or
language
fishing.
and just start a new sentence. The fact of such communication is shall be promptly disclosed to the commission in writing.
Yeah.
Which language are we talking about now?
We're going
No,
back
Yeah.
to where we were before that.
No. We had the language nor we stopped the sentence at commission before. The nor with respect to any other matter is unless is out, and just start a new sentence. The fact of such communication shall be promptly disclosed to the commission in writing.
I think we're talking about non-reauthorized communication. So I think that we need a sentence to say, in the event of inadvertent communication, then that will be immediately disclosed.
Right, it's hard to words, Mr. McGough, but in the event that the communication,
Never.
subject of the communication subsequently becomes a subject for the,
I just think all communication should be disclosed.
Too broad,
I think that's too broad.
too broad, and we are going to our preamble. It's unwise, it's unjust, and we are trying to do that, and I really think it's too broad.
I think if we go back to the prior sentence, though, we're talking about commission-related matters. That's
That is fine.
what triggers the letter if such a communication happens.
If nevertheless such a communication occurs.
Yeah, there you go.
Yep.
Yeah.
That is fine. If
Good.
if that communication occurred related to a matter that subsequently comes before the commission.
Yeah, that-
Subsequently comes before.
I agree with that. Then we-
That's more of a recusal issue.
It puts the obligation to disclose it. You didn't know it at the time. It is related to something that now is before us. We have an obligation to disclose it. And additionally, if it becomes to the point of recusal, then you have a further obligation to recuse.
So we use the word subsequently, comes before the commission,
If nevertheless, something comes, yeah.
subsequently.
So it,
So is this
Okay.
like if in the event of inadvertent communication with appointing a public official or representative,
Relating to a
conversation.
matter,
but a conversation subsequently is related to a matter that comes before the commissioner has an obligation to disclose and in some instances recuse. I'm not right.
And I'm not sure about that one.
I think it would be helpful to the full commission tomorrow if we can try to at least sort of get a sense of what the categories are and maybe where our differences of opinion are, because I think I'm hearing that we all agree on the substance of what should happen for matters that either come before the commission or turn out
Right.
unexpectedly. I feel like I'm actually hearing agreement on that, that it's, that in general, you're not supposed to talk about that stuff with them, and if they come up and accost you in an event unexpectedly, or like, it's an outrage what you all are doing to so-and-so, then we have to disclose and potentially recuse depending on those standards. It sounds like the group agrees on that category. And then it sounds like where we don't have agreement is the category, what I see as two distinct categories. One is commission-related matters, like somebody comes up and says, your executive director is a real jerk, you all should fire him. That's not a matter that comes before the commission. It's definitely not a conversation I want to be having with my appointing authority. Right? Like, I think it's highly inappropriate to have that conversation. I can't solve that problem by recusing, not really. Maybe I can, I don't know. But anyway, my point is that, or the regs, you all really need to change your regulations about lobbying because they're way too burdensome. We may not have agreement on what to do about commission-related but non-matter related. And then the further category of baseball games, where it sounds like I think I'm in the minority about thinking disclosure makes sense in that category, and I'm fine with that. But I just think it'd be helpful tomorrow if we can package these as, we can probably write some language that solves one of those issues, and we can at least identify the options for the other two. That was my thought. And then we still have to define representative, which
Yeah.
we're all a bit.
I think-
Which Commissioner Whittingham and I are particularly interested in.
and I do believe that, based on what we're doing right here, and we don't have the full commission here, so like tomorrow, we're getting their views as well. So I'm not sure that tomorrow we accomplish all of this. We can get as much as possible here, and then we should give the larger group an opportunity to review as amended before we're really voting on what it should be. I also want to say that another place we can look is at our own code of conduct that we were all required to write when we were going before the IRC. Do we look at that and say, hey, is there anything there that we said, looking at this here, or that we want to put here? Because we were all asked that question. And so we can look at it as well. And that's was something that we said we would commit to, we would agree to. And so let's try to see how much of this we can go, the things that may be of issue. We talk about it to the larger, and then when we put forward amendments, we give the other commissioners an opportunity to review it. I think that won't be accomplished by tomorrow.
Well, the goal is that we, as the committee, present what we believe to be a final product to the commission for discussion and ultimate vote.
Yeah,
I don't think we're there.
yeah, but we don't.
Well, I understand completely that we still have much more to thresh through,
Yes.
but the exercise is, obviously, it's a public meeting, and I think the exercise is good for us as well as the public. And so at tomorrow's meeting, I'm certainly not going to be prepared to say anything more than we're working very diligently on it. And I think that's a fair statement. So we've got another 52 minutes. Let's move on.
So tomorrow, to be clear, we're not voting on this as, it's on the public agenda, so we won't be voting on this
I'm
tomorrow.
concerned this will
Okay.
green light, and-
I don't think I have a final product to
Right,
recommend.
right. I thought that's why it was included in the book
We might be
as a
able to.
final product.
Well, that was the hope.
That was our ambition.
So, thank you.
Could,
But reality has a nasty way of coming in.
well, I mean, I do think we may be in a position to say, you know, there's agreement this far, or there's, you know, if we've actually consensed around what I think we have, I wonder if it would be helpful to report
Plans
that.
others have made.
Well, I think the better idea is just to say we're working through it, and we've made significant progress vis-a-vis the manner in which we communicate, with whom we communicate, and how we keep each other apprised of it.
Yeah,
I think that's
That's
in
fine with
the
me.
bottom line.
yeah.
And we can do that either ex parte or with the whole group. All right, the second oh wait, I had a question very quickly with regard to conflicts of interest, with regard to no member shall directly, indirectly, or through another appear, render services, et cetera. Normally, when one does public service, there is a period of time after which they can. For example, I cannot appear in the second department for 2 years. Do we want to think about saying within X number of years after service as a commissioner terminates, you can't do that?
We
That's
do say in here, we do propose essentially or effectively both a 2-year bar and a lifetime bar. Those provisions are in here.
I was thinking, though, in the conflicts of interest, where we make that one statement or refer over to that other area.
I don't quite know
On the
where you
last
are.
page, we have post-commission
Right.
policies, which track sections 72.
Yeah, those are the post-service restrictions.
So you can say, except as provided in post, perhaps just as a reference back. It's in there, never mind.
Yeah, I read it too, the full service throughout.
Yeah.
I have-
I wanted to, tie it together,
Together?
but no problem. All right, we have the second sentence, the second
Before we get
paragraph.
to the second sentence, I had other questions under conflict of interest. So in that same paragraph where you said, no member shall directly, indirectly, or through another appear, render service, interest, against the interest of the commission in relation to any case, proceeding, application, or matter before any adjudicative body. Now, I guess this was in there before. I have concerns about this because I don't intend to. I would not appear before the commission, but my line of work may put me in a position where I am defending an attorney who is accused of some violation, and they're before the Attorney Grievance Committee, which is a totally different body, and I may advocate for my client, and that might be different from what the commission thinks should happen. Similarly, this might not always be the case, but as an adjudicator, a referee, a potential adjudicator, a referee on the Judicial Commission, if I opine on something, I mean, let's say the judge leaves the role and they do something else, it's within, I think, 150, 120 days, or something is before the commission, and I'm making a recommendation, I could be recommending something different from what the commission says.
The Commission on Ethics?
No, there's a judicial ethics versus the commission on
Right, but-
ethics, or it says any adjudicative body, or,
But the Commission is the commission is referring to Colig.
Against the interest of the commission he's talking about. That's
Yes,
basically-
I understand that, right? But a lot of lawyers are lobbyists, okay? They could get into trouble. I defend lawyers 90% of the time.
But in trouble under the POL, under the Lobbying Act, or in trouble for some
With the
other?
grievance committee, but sometimes one misconduct here could also be misconduct under the rules of professional conduct.
Right, but what about under the Lobbying Act, which brings it within our jurisdiction? If-
So it could be, it depends on what that is. Like, give you a perfect example. In one of, I read most of the reports for, let's say last year, the Judicial Commission sanctioned a judge. And the reason for doing so was because the FDS report that she filed was inaccurate. She did not disclose a $50,000 loan
To whom, to whom?
to us.
We don't
The-
get,
the-
We don't do
the-
judicial.
we
I'm
don't
sorry?
get,
No,
we
you
don't
didn't
get
do
judges'
You didn't.
FDSs.
You didn't. Go ahead.
For the public,
We don't get-
we don't get that at
We
all?
don't get justices of the Supreme, we don't get FDSs from anyone in the judiciary.
No, but the example would be an attorney.
Unless-
Right,
In
so
an
the
agency,
person
it
filed
has-
the thing, and
Right.
what she said was filing the FDS, right? And that was the premise for the
disciplinary action.
disciplinary action, because the information there was inaccurate. So you're saying,
We'd never see any of that.
But you're saying.
That's never
That was
fought.
for a judge, but you're saying an attorney could be subject to the
the
same
same thing. The-
discipline from.
But if you're representing that attorney, wouldn't,
You have to.
Right.
you have to recuse.
You have to recuse yourself.
I don't mind recusing. It says, it didn't talk about recusal
It
here.
says she
It
can't
says that we
engage in the representation.
She may, in her defense of her client, say, the commissioner's reg, the reg governing this is flawed, or the commission misinterpreted,
Right.
or et cetera.
Right.
Which
I
could
could
be
make an
perceived
argument.
as, right,
that is not in line with the conclusion
right.
that you may draw here, based on just representing them. So it's like any adjudicative body, I find that, especially because of what I do on a day-to-day basis, to be very limiting, just broad, any adjudicative.
But
body.
wouldn't you be conflicted out in any event in that circumstance if you had been a commissioner while that matter was pending? I
If
mean,
the matter was pending, absolutely, right?
Yeah.
I wouldn't do
couldn't
that, but
take it.
I would not take on that matter. But we also go back to, the matter ends here, for example. Sometimes a investigation can take years, right? And it ends here, but it's still being investigated there. I would never take on a matter where it involves someone that's before the commission. But there is a possibility that I could take on a matter that's maybe not before the commission, or let's say one comes before the other.
A positional conflict you're talking about. Is that you?
It could be a positional conflict. It could be a positional conflict. And I may, in advocating for the client, make an argument that is not the same that I just think like any adjudicative body, I think we recuse ourselves if there's something that we know of. But if we're lawyers and we're actively practicing outside, we may be before a court, we may be before a grievance committee, another commission. How does that work?
Can I ask a question?
Well, she's got a question on the floor.
Well, no, I mean, it's a clarification of Commissioner Whittingham's point. So is the situation you're envisioning, I can see different kinds of conflicts which you're talking about. So one is like an attorney's getting disciplinary charges because they engaged in some allegedly shady real estate transaction. They didn't disclose it to all kinds of places. One of them is RSS form, which would still be misconduct under the lawyer disciplinary rules because it's material misrepresentation.
Yes.
I don't see any reason why our rules should stop you from arguing like, hey, this guy didn't do it. Like, didn't do that thing. But this goes beyond that. The language here,
Says-
not only would it cover that situation, so that's sort of in support of your point. It does seem to me a bit awkward if you, in the course of defending that client, argue that Colleague's rules are unconstitutional, right?
Yeah.
Which you might have to on behalf of the client in some situations. I'm just saying, it seems
Yeah.
like those two are sort of different to me. Like, when we talk about against the interests of Colleague, to me, I don't think we care whether attorney X did or didn't engage in certain conduct, but it does create a real problem for us if one of our commissioners has to argue that our actions are unlawful or rules are unlawful.
I mean, absolutely. I mean, I don't think, I rarely go to the constitutional argument, but in defense, but I don't think that I would make that argument, or that's something, that is definitely one of the areas that I can say, yeah, we can't say it's unconstitutional in that respect. I don't think that's an argument. I'm talking about the first instance. They did not disclose this on the FDS. That's required. It's material misrepresentation on the 8.4C. That's a big issue, and it's knowing. And then if I'm defending the person, I may have to say it was not knowingly, right? Because it's not until Giuliani in 2021 that the courts now put in the word knowingly for a violation of 8.4C. I may want to make that argument that it's not knowingly.
How is that then an argument against the commission? How would that disparage the commission or?
Because it's the FDS form that's filed here. And if, there's certain action or you take.
Because the lawyer is a state employee?
It could be a
Or
state
a member of a
employee.
board, a state board or
Yeah,
something?
It could be, it could be, it could be, it could be. I don't have an instance today. I am just thinking based
Yeah.
on what we're doing. Yesterday,
But is
I am giving a presentation for the military law committee in Fort Hamilton. I'm doing conflicts. Someone comes up to me, and I mention rule 1.11 and 1.12 dealing with government and public employees, or judicial and neutral. And I made a reference to those rules under the rule of professional conduct. The person came up to me, right? There's a public servant. And the person talk about public officer, say, I work for the government, there's also the POL and this and that. And I wasn't talking about this. And that's what an attorney came up to me yesterday and said in that respect. So it could be in relation. That's just an example that just took place yesterday.
But,
That's a public officer.
and therefore, what should we do with our rule? What are you suggesting?
I think that any adjudicative body is what I'm saying is a little broad.
Well, you can't specify, because then you could end up, I think the thing here, it seems to me, is that the principle behind this is to pull this thing to a higher standard, to require us to think strongly about the kinds of things we get ourselves engaged in professionally. And I think that if you, as an attorney, found yourself in conflict with this agency, then any attorney would have some decisions to make in that regard. But I don't know that we can reconfigure this language in a way that would capture what you're trying to capture without lowering the standard. And I would be against lowering the standard.
Go ahead.
And you remind me of a point that I intended on making at the outset. And this may go without really saying, but the code of conduct for the commissioners goes above and beyond what is minimally required in the POL. Admittedly, there's already a code of ethics by which you've committed yourselves to abide, Section 74 of the POL. Notwithstanding that, because of this commission and your commitment to improving the public perception of its integrity as compared to predecessor agencies, in the plural, you're being presented with rules that require more from you than the statute does. that's a given. So the question, I'm reminding us, so the question that's begged is, how more do we want to elevate and raise that standard above the bare minimum in order to reflect the earnest commitment that we've made to holding ourselves to a higher standard, as the chair says?
And
That is
with-
fine.
Without dragging this on further, may I suggest that there's a different example? What happens if you're dealing with a case and it turns out that that individual, you didn't know it at the beginning, but that individual at some point turns out to be a former client, turns out to be an adverse party in another matter? You're going to say, oh, I got to stop, and I have a conflict, and you get out of the case. And that may be what has to happen here. But I'm not sure we muddy is not the right word, that we water down to the point that takes into account all those possibilities. I mean, you've been practicing for a while, Kaylin, and, you're saying it's never happened before. Who knows if it'll ever happen again? It never happened at all. And so that's the concern. Ed?
There's a similar rule, like as former appellate division judges, we can't, to your point, appear before the appellate division for 2 years. Now, if somebody comes to you where they've been a client or potential client has had a case before the appellate division and you were involved in it, you can't represent that client in any further proceedings anywhere, not just limited to the appellate division or 2 years. And so this is sort of a similar rule. You can't come before us for 2 years if you leave here. And if you were involved with the case when you were here, it's just an inherent conflict that you shouldn't be representing that individual in any, before any agency.
All right, so
I think here it says before us.
That particular transaction.
If the commission has an interest in it, you cannot represent, presumably for compensation, anyone in a proceeding anywhere else with respect to interests that are in conflict with the commission's interests.
Okay.
But you understand, that.
I definitely understand. And our post-commission policy, as I read them, the 2 years and the lifetime bar is applicable to matters that are here before the commission that you were substantially involved in.
But what if you're not? This proposed rule would capture those matters that you were not personally involved. There's no personal participation that would invoke the lifetime bar. Because the lifetime bar is matter specific.
Right. And you're saying this, we want to go even further.
Mm-hmm.
I can see us going far with some things, but I really think we have to be careful about how far we go. So, and I guess we're going to have a list of, this was, nothing can be against the commissioner's interest. We're going to know all of that and still have a list of them forever when we leave here. I really think we're going too far. I understand the lifetime bar for anything that we were involved in and cannot come before the commission. I support that, but just anywhere else for a lifetime is a heavy burden.
Wait, I'm sorry. This provision doesn't apply after we leave the commission.
They're saying yes. They're
It says
saying
no
yes.
member shall. You're not a member after
Not a
you're on the
member.
commission.
Yeah,
Right, but what he just
After they're
explained,
leaving the commission. No, it's post membership.
he's saying
Wait,
post
against
as
the
well.
interests of the commission after we're gone?
no, we're
That's
sort
not
of
it at all.
conflating
That's not what it
the
says.
provisions. The lifetime bar is not doing anything for the rest of your life on a matter that
That you
you
were personally involved in?
here
Absolutely.
at the commission.
Yeah.
Absolutely, and I'm in agreement with that, but
Yeah.
I thought what Commissioner Carney said was beyond that, and that you echoed that point, say it should go beyond that, beyond what we were substantially involved in.
I think,
Commissioner James.
You'd have to be
Oh,
direct.
no.
Commissioner James.
I think what we're trying to address is a situation, for instance, if the person is charged in the disciplinary proceeding with violating the Lobbying Act, and not disclosing information. I think what we're saying is in those situations, even though it's a problem for your practice, that may be a case that you shouldn't handle because there's an inherent conflict, you know, and that you should maybe refer to somebody else.
And does that apply after you've left the commission?
No,
No.
no.
Okay.
No.
Was that what you said, Commissioner Carney?
Yeah, that's what I thought we were talking about, this
Okay,
lifetime
okay,
prohibition.
No,
okay,
Okay.
yeah.
okay.
This is Kavita. Can
Some
you,
slight misunderstanding on my
hi,
end.
this is Kavita. Can you guys hear me?
Yes.
Hi. I just wanted to, I think there was some confusion. The conflicts of interest provision applies to you as a commissioner now. The post-employment, the 2-year bar, the lifetime bar, that is after you leave the commission. So exactly what I think it's Commissioner James. I can't see you on the screen, but I think that was Commissioner James who just spoke. The conflicts of interest provision, you know, that speaks to, correct, if you are, Commissioner Whittingham, if you're, you know, you're an attorney and you get a client who is arguing that our lobbying regulations are improper, that is not a client that you can then take, right? The post-employment restrictions that are at the back of, on that last page, that talks about the 2-year bar and how you can't, you know, appear or practice before us or render services for compensation for a period of 2 years. And then the lifetime bar, those are on particular matters that you may have been personally involved with. Let's say, I don't know, the helping to draft certain other regulations. And if there is 5 years from now, if there's litigation on those new regulations that you had worked on when you were a commissioner, you would not be able to work on, you would not be able to take that case 5 years from now, if that is a matter that you personally participated in. Does that make sense?
Yeah, that's
I
what
understood that.
That's what I thought we were talking about. So for example, if I'm on the commission, we dealt with a particular individual, a violation, and I participated in that now when I leave, I have a lifetime prohibition from representing that individual with that transaction before other agencies.
Correct. Before any other state agency, correct.
Right. Because we had intimate involvement with the particular case at the time we sat on this commission.
That's with respect to any other state agency.
Right.
Yes.
Yeah.
So the lifetime bar
I
applies
think,
with respect to a matter that you have directly participated in, were, you know, personally concerned with, you know, whether it's an investigative matter or certain other matters before the commission that you took a role in, you know, were directly concerned with. And then if that somehow gets before another state agency, you would not be able to participate on that, on the other
I
side.
think that Commissioner Whittingham and Commissioner James, I think that's what they were talking about. So for example, if an individual was, we had an individual that violated some lobbyist provision or et cetera, and we sat on the commission when that took place, and then we were to leave, we wouldn't be able to represent that individual before the grievance committee if it was that same transaction that individual found themselves before the grievance committee. Is that Commissioner Whittingham? I think that's the fact pattern you were concerned about.
So as I hear it now, we can't do any state agency. So let me ask another question. So you have the grievance committee in state and the federal bar, where they would probably have reciprocal discipline or something of that nature.
if I may.
Is that something?
We've got so much to cover, and it's,
Okay,
you know,
that's fine.
and, you know, rather than individualize this, I think we need to look at it on a broader view, and that we move forward.
I think a broader view is great, but I think we have to ask questions, because without questions, we don't know what's prescribed and what's not. And it is appropriate to ask questions so you know that ahead of time.
Moving forward. Is there anything else on page 1 that we need to discuss?
Mr. St. John knows about the question about the meaning of representative, so I'll just
Okay.
assume that'll be taken up at some point.
Yeah, I mean, I think I can resolve it with just some wordsmithing. Again, unless
I wasn't
there's-
asking for it to be addressed now, I just wanted
Yeah.
to flag that it was a continuing issue for us.
I don't want to prolong it, but I do think that what you were suggesting is too limiting, because they don't always say that they're representing me. Suppose it's like the first assistant attorney general. That person is a representative of the attorney general, and that person may be speaking to you, and they may not have been designated to act in their stead, but they could come to you and talk about it. So that, I think that we need to be careful about defining who the representative is, because there are people who speak
Yeah.
for the attorney general.
I
Not necessarily
I agree,
having
and
delegated
perhaps on a
role.
case-by-case basis, we may want to get from the person on the other side, you know, some documentation that they've got authority to speak for their principal.
I think it goes beyond
No, it can't be a matter of formally delegated authority, because the office is full of people, they change all the time, and anybody can take an instruction to reach out to somebody.
I'm still convinced, as maybe impractical as it seems, but I don't think it's that impractical, that we simply disclose the conversation. And then if subsequently there's something there that presents a conflict, then we recuse.
Oh, no, I know, but that's a separate question from disclosed conversations with whom? Like, do you cover the interns? And if you don't, why
Right.
not?
Well,
Do you see what I mean?
yeah, so you've disclosed that you have interns that work, work for the attorney general?
I have students who are currently.
Who are currently interns for the attorney general. Yes, disclose that.
Yeah,
And then we
like I
move
said,
on.
I'm fine with that solution. I don't think
Yeah.
most of my colleagues are.
Uh,
But I didn't mean to raise this again. I just wanted to flag that there's still a question for discussion.
But I think that the disclosure, I mean, that's after the fact, but we're talking about if the deputy attorney general is going to speak to you, that should be something that you get prior
Definitely,
authorization.
no question about that. I would say anybody who wants to speak to us from one of these appointing offices, we should get prior authorization. If it's a phone call and you pick it up and they're there, then we should disclose.
Right.
And that's applicable, so the governor has secretary of this, secretary of
Everything.
that, secretary
Yeah.
of the other.
Yeah, no,
I
look,
mean,
look,
I
I
am
was-
friends
I
with
was-
individuals
Same here.
who are there.
Same here. I
So
was
you
in
can't speak to them?
I was at an event, no, it's not that you can't, you simply disclose.
Disclose.
I was at an event with the Vice President Harris a couple of Fridays ago. There were several state officials there. I sent these guys an email pronto, identified who those state officials were, so I don't want to get in trouble. So I don't think it's that difficult. I mean, we all have our little handheld things, quick text, quick email, just to disclose.
And if you don't know at the time the conversation takes place, but you subsequently learn of it, then disclose at that time.
I maintain that it's unreasonably burdensome to do so.
Well, I maintain that we're on this commission because we have set a higher standard. And we
Absolutely.
have to set a higher standard. And that's just a given. We're
And
in a state that has serious ethical challenges in its political life. This is a burden placed on us, but it's one we've chosen. And it's going to be very hard to configure these principles by which we're guiding ourselves to fit our particular circumstances. So I would say it's more transparency, more taking that extra step, more bearing that burden, because that's what we've chosen to do.
We have chosen to maintain a higher standard, I agree, but I believe as in our preamble and what has been set out, it should not be unjust and unwise to.
I'm sorry, I didn't hear the beginning part of what you said, Kayla.
As in our preamble, where it states clearly, it would be unwise and unjust to prescribe them by statute with inflexibility and penal sanctions, which would limit public service to the very wealthy or the very poor. It is very similar. This is not a statute, but it's a code that we are going to vote on, and we should treat it as the law of the land. And so we should be careful not to make it unjust.
But this is a preamble to the creation of the commission. What we've been discussing is our rules as commissioners in performing our duties.
And I do understand that. I do understand that. But we take it from here and we take it from we have to be practical.
Well, I want to argue that there is an impracticality to this higher standard, and that we have to embrace that if we're going to do this job. It is burdensome, but that's why we're here. That's one of the reasons we're here, and that's one of the reasons we have a new commission with a new code of conduct for commissioners. And it is a challenge. I could have some other colorful language for it, but it is a challenge. And we're just going to have to step up and step into it. I don't think there's a lot of alternatives right now.
And just to emphasize the point, the paragraph that we've now been emphasizing was not in the JCOPE standards. And that may be in part one of the reasons why.
Well, slight correction. All
right.
So this is modeled on the prior predecessor agency's code, but I remind us the context in which this preamble has been set forth. It's a preamble that was articulated by the legislature with respect to Section 74, the Code of Ethics. Again, what the proposed Code of Ethics is doing, or attempting to do, is go above and beyond the inflexibility of the statutory language. All this is not statutory language. This is on top of the statutory language, which the legislature doesn't want to be so rigid and inflexible. That's the statute. But now we're talking about something else of greater import than just the statute, which is not supposed to be inflexible. No one says these rules are not supposed to be inflexible, just the statute is not supposed to be inflexible. But these rules, in order to require of commissioners greater obedience than merely abiding to the statute, there's a distinction there that matters.
So we want it to be inflexible. So all I will say on this is we are held to a higher standard. Most of us have always been. We know that, and we abide by it. But we should be reminded that we're human. And so we should not do things that we really probably put ourselves to fail. That's all I will say on it. Higher standard, absolutely. I've always upheld a higher standard. I'll continue to do so. But I'm human, and I think we all are. And we should be reminded of that occasionally.
I'm going to try to address apologetically the 10 minutes that I've got left. An item that I mentioned with the committee chair that I just want to draw our attention to, as I've again taken another really close look at these proposed rules, there is a provision under procedure for recusal.
What page are you
That I don't know.
Page 3.
Page 3.
Oh, you're
Page
the,
3.
Okay.
Page 3 on
Yeah,
the H.
I'm not working from
Yeah,
the
we got
book.
page 3 on the H.
So I'm looking at a bullet. It's going to be So under procedure for recusal, 1, 2, 3, 4, 5, 6, the sixth bullet, starting with, it is possible that matters may be added to the commission meeting agenda.
Oh, that's near the bottom
Near the bottom of page 4.
No.
Yeah.
Oh, that one didn't have a page.
That whole paragraph, I really think ought to be removed from this discussion of recusing from voting, or recusal generally, and replaced, moved from recusal and placed in the section of these rules that govern or provide for abstaining from voting. In other words, on the occasion when something is added to a meeting agenda after the meeting book has been mailed to you all, something that is late breaking or just happening, and so there hasn't been much time or enough time for the commissioners to digest it, rather than using that as justification for recusing from voting. I think it's a better ground for abstaining from voting. The rationale being, abstaining from voting should occur any and every time a commissioner doesn't feel adequately informed for one reason or another enough to vote on a particular matter. Having an item added to the agenda at the last minute certainly qualifies as not being sufficiently informed about the matter to come to a meeting prepared to discuss it. So one might want to simply abstain from voting, but one should never, in my estimation, recuse from voting, because again, and I make a big point about this because people confuse it all the time. And there's literature on what the difference is between abstaining and recusing from voting. Recusals only should arise out of a perceived, an apparent, or an actual conflict of interest. Not knowing something or not wanting to vote on something for whatever other reason, that's when one should abstain.
Well,
rather than
yeah, I mean, this was also, you're absolutely right. It should also cover the abstention component of this, but at the same time, we will have instances where in the course of a discussion of a matter, some individual may be identified as a witness or interested party wasn't picked up, so an individual may in that instance find that they do have a conflict. Because staff is not infallible and we don't always know the full scope of the discussion and the turn it may take. So it may make sense to have it in both places.
I'll take a look at that.
It does happen. We're trying to conform because there are two things going on. We have a statute now that has a recusal provision in it, in executive law 9410B. There's a procedure, so we have that here. So we have two things going on. We have the investigational and enforcement matter recusal, and then we have everything else, including guidance.
I have a question to that point, conforming with 9410B. So, for example, right above, 2 paragraphs above the one you just read, where it has members may request counsel to review what they believe may be a conflict and request an opinion. But in 9410B, we are told that we're supposed to notify the members of the commission of the possible conflict. So my question is, why is this necessary here? And why is it that we're not notifying the members of the commission as provided there in 94B?
Again, this goes above and beyond what's already required in statute. So in addition to following the statutory prescription with respect to what one does, if they believe there may be a conflict, this proposed rule is discretionary. Just allow it doesn't require members to seek counsel from general counsel or the executive director. It simply allows them to seek that additional resource for consultation.
I don't have the statute in front of me. Is the distinction that we send out the letter for 10B when we know we have a conflict? But this section deals with if we're looking for an opinion, and then we'll make a decision because it's only advisory. And if in fact we determine it is a conflict, then we would comply with 9410B and send a letter out to the other members of the commission. This is just the beginning. This isn't, you haven't determined you have a conflict yet. That the difference?
9410B said possible conflict. So it didn't say determined, it used the word possible. So before you actually know as well.
Yeah, okay.
And- Yeah, and then there's so although our executive director is an attorney, do we foresee always having an executive, an attorney being an executive director? Why would go there first?
I think we should make it a requirement if we don't, but that doesn't get at your question. As a non-attorney on this commission, I think it would, I don't think you could have an executive director who isn't an attorney.
See, so that's not a requirement. Because I was wondering why it didn't say ethics or general counsel. Yes, they do report, but, to an executive director, but I didn't know that, is that a current requirement, or is that something that we would have to add?
It would have to be added. I think historically, in the history of ethics commissions in the state, I don't think there's been an instance in which the executive director has not been an attorney. Don't think that's the case.
Okay.
And let me point out that part of the mechanism in 9410B is that even if a commissioner were to conclude that he or she does not need to recuse, nonetheless, the other members of the commission could override that decision. So that's a statutory authority
Yes.
that applies at least with respect to investigative and enforcement matters.
No question there.
Keith, anything else?
Well,
I'm sorry.
I'm not sure if this fits quite within it, but I had an overall question as to whether, if you do recuse yourself, whether that should be public. And I've been involved in a conflict in my own head about that. I had a conflict on the Cuomo matter. In fact, I asked for an opinion from the executive director on whether I should.
Let me just remind you, we're in public session, so we don't want to get into the substance of
Okay. So the question would be
such things.
whether or not that should be, thank you for that reminder, whether that should be public as a matter of course if you decide you should recuse yourself. Should that be the policy? Should that follow a recusal decision?
My initial response
Thank you, Sandy.
would be yes. Because it goes to transparency and it goes to increasing the public's confidence in the work of the commission.
The only thing I would add is that
Okay.
perhaps there would be an announcement that there was a recusal, but without specific reference to the matter,
To who?
since that
Oh, that's
matter is
okay.
not subject to disclosure.
Yeah,
Okay.
Yeah, I mean, it's public to the extent the matter becomes
yeah,
public.
exactly. To the
But
extent
if,
that the matter becomes, yeah.
in fact, you decide to recuse yourself on a matter, and the commission may know it, and then the matter is decided, and the public doesn't know that you recused yourself, someone's going to say, oh, that guy James who used to represent Joe Smith, he must have been defending Joe Smith. And that would lead to an unfortunate
So
conclusion.
that's why I'm suggesting that it be made public that there is a recusal, and then when the matter eventually becomes public, you can state which matter.
Who was recused?
No.
Right.
The matter of recusal would be public, but with respect to, but the actual, the fact that a commissioner or commissioners are recused would be a public thing. However, the actual nature of it would be confidential. So if it is an investigatory matter, our statute requires those matters are kept confidential. So it is.
And in addition, sometimes you want to have full disclosure. In other words, you would recuse and you feel like you should tell the reason, but there's times when your reason is going to embarrass or somebody else, where you can't get the particular reason publicly.
Right. So the reason for recusal may not necessarily be public. The commission, it's in the commission's interest to ensure that in the day-to-day operations that there's, commissioners are recused from matters that they should be recused from where there's a conflict. However, depending on the matter, that may be a confidential matter. And so that would not be disclosed to the public.
Yeah, for example, if I was a physician and I was treating the patient and they also have a matter before us, I have to recuse, but I can't tell you why.
Correct.
Public.
Correct.
I think the fact of recusal in that situation, for better or worse, is non-disclosable under 9411 of the executive law, and I think it has to remain that way until the matter is concluded, and if it concludes in a way that results in disclosure of the matter, which may include a vote, it would be disclosed at that time. And I think there's no, and we've looked at this very closely, and there doesn't seem to be any other way to thread that needle. We have an obligation to maintain confidentiality.
Okay.
I have a question about the final paragraph of page 4. Isn't it more limiting for us to say if you choose to recuse yourself, you inform the chair versus informing the entire commission as provided for?
Well,
I don't think it
it's probably a
matters.
policy decision for the,
Yeah, I mean, we
It says
can,
that the chair and the statute says the entire commission.
Well, that's what we're segregating the investigative and enforcement matters that are governed by Executive Law 9410B from all other matters. So these bullet points are
We don't say that, though.
non-investigative. That doesn't answer the substantive question, whether the notification should be to the chair of the entire commission, but in non-investigative matters, if they don't involve protect confidential guidance matters, then the fact would be known, if something we're dealing with in public session, it would become part of the public record.
Well, we
Yeah,
have,
but
we have the bullet point with the arrow that relates to investigation and enforcement matters at the
Correct.
bottom of 3. And
Yes.
then with the bullet points that are dots, those are all,
All other matters.
all other matters.
All other matters.
So we're clear.
But in sticking to our theme, to be more transparent and for disclosure, I think the entire commission should be informed.
that's fine. I would support that.
be excused.
Please. Good luck tonight.
We're watching.
So Scott,
Thank you,
We'll
Keith.
watch the chimney.
they'll fill you in.
Good luck.
I'm helping pick the next bishop of Albany.
See you tomorrow.
Good luck.
God willing.
As they say.
Okay, generally, since we're limited in time, is there anything else in general that we want to discuss before we then come back to the nitty-gritty at our next meeting?
Well, I had one specific on the committee, or when meeting guidelines, even though I hadn't touched that at all. If you want to raise that, which is on definition of meeting, on the quorum, how we're going to define a quorum of the committee. We're saying that we would have to disclose if it's a quorum of the commission, but if there's 3 members of the committee showed up, is that a public meeting? And I think we've been advised, yes. Shouldn't we deal with that?
Yes. A quorum under the general construction law is a majority of the members of the body. So if it's a committee, majority would constitute. If it's a committee of 4, 2 would be sufficient.
That needs to be revised then.
Okay,
Okay.
All right.
we will do that. And let me point out, there's a typo in the code of conduct in there, in the lifetime bar provision. In the middle line before to any case or proceeding, should be relating to any case or proceeding. I got lost somewhere in the enjambment of the sentence.
So let me ask
I'm sorry, where, Sandy?
On the last page, no member after leaving the commission under post-commission policies, the second paragraph. The third line down, or other entity, comma, relating to any case. Proceeding application or transaction.
Just a question back on the definitions. And this may be the law, so it can't, but I just have a question where it says commissioners shall be deemed to participate for the purposes of a quorum when present in the same physical location or locations where the public can attend. In those cases where we have the emergency provision that someone can participate remotely, do they not count toward the quorum?
They do not count toward the quorum. So consistent with Public Officers Rule 103-A, they do not, they can vote, but they do not constitute a portion of the quorum.
That may be something worth taking up with our legislative agenda. Yeah.
Yeah, that's what
With
you're.
respect to the open
It's
meetings.
strange.
All right, I think we've come to our time limit. Let me thank everybody for their participation and certainly interesting comments. I read this 3 times and I didn't catch everything, so the fact that we have helped each other by coming up with more than we anticipated. And I'm proud to announce we finished the first page of the proposal. So we do have our work cut out for us, and we will do it. And we will do what we can to accomplish it as quickly and effectively as possible. Thank you all very much. I'll entertain a motion to adjourn.
So moved.
Commissioner Cardozo, seconded by Commissioner Ayers. All opposed? All in favor? All opposed? Any abstentions?
Not a lot of them.
Thank you. We're adjourned.
Oh, I should wait until we